I've shared my screen. I hope everybody can see the title slide, handling complaints under the SASH policy. My name is Tim Purvis. I work at the National Church Office for the Presbyterian Church in Canada, and I am the Associate Secretary of Ministry and Church Vocations. And I want to welcome you all to our webinar this afternoon, Handling Complaints under the SASH policy. And what we're hoping to do with the webinar is to provide just a brief overview of the process for handling a complaint under our sexual abuse and sexual harassment policy through the 4 stages of discovery, intervention, investigation, and adjudication. The presentation part of today's webinar is going to be recorded, and following the presentation, we're going to stop recording and we're going to have a time for questions. And I'd ask in advance that you would keep your questions general. If you have a specific situation in mind, please talk to me later offline to protect confidentiality, and I will be happy to answer the questions. Let's begin with prayer. Loving God, we gathered today to speak of difficult things. Give us openness in heart and spirit in our learning together. And should we be called upon to deal with such challenges, give us a courage, honesty, and wisdom beyond our own, that all involved may know your peace, healing, and understanding. In the name of the coming one, Jesus Christ, we ask. Amen. We acknowledge that we all live and work on the traditional lands of many different Indigenous peoples. Today, I'm located at the National Church Office on the traditional territory of the Wendat, the Anishinaabe, and the Haudenosaunee peoples. These lands are part of the 1805 Toronto Purchase Agreement, Treaty 13, which is held by the Mississaugas of the New Credit. These lands are also part of the Dish with One Spoon wampum. We acknowledge the land's significance for the Indigenous peoples who lived and continue to live upon it, and whose practices and spiritualities are tied to the land. We acknowledge the treaties that were made regarding many of the lands we live on, treaties which exist still. We acknowledge the Church's role in colonization, that as a church we have been involved in colonial practices and structures that profoundly harmed generations of Indigenous peoples and families and communities, including our operation of residential and day schools. We reaffirm our calling and commitment to truth, healing, and reconciliation with Indigenous people, and ask for God's guidance as we seek intentional actions to end anti-Indigenous racism and uphold the dignity and rights of Indigenous peoples. So I want to walk you through how we handle complaints through our sexual abuse and sexual harassment process. And the process has 4 basic steps. There is the discovery phase. This is what happens when a complaint first arises. There's the intervention stage, where the initial steps are taken after the complaint is received. In the investigation stage, that's when interviewing takes place. The complainant and the respondent are interviewed, evidence is gathered, and a report is prepared. And finally, there's the adjudication stage, and this is where decisions are made about whether or not the allegations are substantiated. The first stage, the discovery stage, well, the complaint is received. So suppose you are a minister and you go to your office on a particular day and you anticipate that your day is going to be just like any other normal day, And then when you get there, you get a phone call or an email, or someone shows up at your door and you hear about an incident that could be a possible complaint under our sexual abuse and sexual harassment policy. What do you do? Well, the first thing that you might want to do is to indicate to the person you're speaking with that the Presbyterian Church in Canada takes allegations seriously and that we have a process to deal with them. You will want to refer them to the appropriate person. All of our complaints under our SASH policy have to go to the court of jurisdiction. So if it is a complaint against a minister or a certified candidate for ministry, those complaints go to the presbytery. So you will want to say to the person, you should contact the moderator or the clerk of the presbytery. You should provide them with the contact information. And maybe you may want to make arrangements to accompany them to that meeting. If it's a complaint against a lay person, someone in a congregation, those complaints are dealt with by the session. And again, you would ask the individual to contact the minister or the clerk of session of that congregation, and you may want to arrange to accompany them to that meeting. When you're having the conversation, take basic notes with particulars. Who was involved? Where and when did it happen? And what happened? Ask the individual if they want to make a formal complaint to be investigated under our SASH policy. And this is an important part because our policy is complaint driven. If we don't have someone who is prepared to step forward and make an actionable complaint, we really can't follow up on it. Now, that said, there is a provision in our policy for third-party complaints. And these are complaints from people who are not direct victims, but perhaps they have observed some behavior or heard about it, and they are willing to come forward and to report it. The complainant is also informed of their right to take their complaint to a provincial human rights commission. Sexual harassment is a violation of every provincial human rights code, and this is a civil remedy that complainants can avail themselves of, and we will want to point that out to them. Now, just going forward for ease of walking through the process, at this point, I'm going to use as the example of a complaint against a minister, recognizing that there are complaints against members and laypersons, people in congregations, but I'm going to use a complaint against a minister for my illustration purposes. The complaint is referred to the Standing Sexual Abuse and Sexual Harassment Committee of the Presbytery. Now, our policy mandates that all courts of the church should have a standing SASH committee, but for various reasons, many of them don't. So if there's no committee, then the presbytery creates an ad hoc committee of, say, 3 to 5 members to follow up on the complaint. The committee members don't necessarily have to be members of the presbytery, but they should be members of the Presbyterian Church in Canada and accountable to the presbytery. The committee should have at least 1 member of presbytery. And when the presbytery is looking at who to appoint to the committee, they should consider elders and lay people who have relevant gifts and experience. Watch out for potential conflicts of interest. Now, those with personal or professional relationships with one of the parties in the complaint might not be able to act impartially or be seen to act impartially. So it would not be wise to appoint them to the committee. Now, both the SASH committee and the presbytery can seek guidance and advice from Ministry and Church Vocations. We are here for you as a resource. Please do not hesitate to contact us. The SASH committee can also start its work immediately before a presbytery meets. though a special or an emergent meeting of presbytery might be called if it's considered necessary. So one of the first things that the committee will have to do is to determine the nature of the complaint. Do the allegations involve criminal actions? And these are typically actions that involve minors, actions that involve physical force of some kind, or are they non-criminal? And not all sexual misconduct rises to the level of criminality. Inappropriate sexual comments about someone's body, for example, or sexual advances made with implied promises of reward or threats of reprisal, those are serious, but they don't rise to the level of criminality. Check the Criminal Code of Canada. There are excerpts of the code in the back of the SASH policy document, or you can refer to the current version of the Criminal Code online. And if there is any doubt, seek legal advice. Ask the police, ask a lawyer. If the allegation is about a criminal activity, then you have to inform the police, or if it involves a minor, inform the appropriate child protection agency. And when this is done at this point, the church's processes are put on hold until all of the criminal investigation proceedings are through. And this happens regardless at what stage it's at. If subsequently there's a discovery made that there is the allegations of a criminal nature, the church processes would stop then too. And they would resume only when all criminal investigation proceedings have ended. The committee informs the respondent, the person against whom the complaint is made, that a complaint of sexual misconduct has been made against them. And this is going to be a difficult conversation. You will be the bearer of unwelcome news. Remember your role. Be professional. Meet with the respondent in person. Take one other member of the SASH committee along with you for that conversation. Explain to the respondent that a complaint has been received and the presbytery has a duty and a responsibility to investigate that complaint in accordance with our SASH policy. Do not get drawn into a discussion of the allegations beyond what's needed for the respondent to understand and respond to them. Indicate that the committee will be providing support to the respondent, an advisor to help them navigate the church process, and a pastoral care person to walk with them. And be prepared for a defensive reaction, and maybe a strong one, like, I'm going to sue you. Don't be intimidated by this. You are carrying out your responsibilities in accordance with the policy of the church, so maintain a calm, non-anxious, professional presence. A special or emergent meeting of the presbytery could be called at this point if necessary. In the intervention stage, the committee arranges for advisors and pastoral care providers for both the complainant and the respondent. An advisor is not an advocate performing a quasi-lawyer-like role. It's instead someone who will provide assistance and guidance and advice in the church process. The pastoral care person is like a personal chaplain to the complainant and to the respondent. Presbytery also has to make a determination at this point whether or not to place the minister on a leave of absence with pay. Now, if it involves criminal matters or criminal investigation, then a paid leave of absence is mandatory. So the minister is put on a paid leave of absence without prejudice In other words, without any assumption of guilt or innocence. If it's a non-criminal matter, the presbytery has discretion. This is a judgment call. It depends on the nature of the allegation. If it's an allegation involving, say, an unwanted kiss of a 20-year-old choir member, maybe yes, the presbytery might consider a leave of absence with pay. If the allegation involves sexually offensive off-color jokes, maybe not. That might not be an instance where the minister will be put on a paid leave of absence. If the minister is placed on a paid leave of absence, or a leave of absence, then the presbytery names an interim moderator, and the interim moderator will act in addition to all of the other normal duties as a conduit of communication between the presbytery and the congregation. And I know one of the big challenges at this stage in the process is rumor control. Rumors it's like dealing with feathers cast in the wind, but we try to do our best. The congregation is also informed. And this is something that the interim moderator could do. And one best practice would be to read a prepared statement to the congregation after the Sunday service. And keep it simple. Ministry and Church Vocations can assist you with this. We have some template statements that you can look at and use as an example. But something simple along the lines of, this is to notify you that a complaint of clergy misconduct has been filed against minister's name with the presbytery's name, and we are processing this complaint and will report our findings to you as soon as possible. The minister will be on paid leave of absence until the matter is resolved. And if you have any questions regarding this matter, please contact, and then the name and contact information of the interim moderator. Do not give out the name of the complainant, and don't discuss the details. I mean, at this point, it's inappropriate to do so as the matter is under investigation, and that's basically what the congregation needs to hear. If a criminal investigation process has concluded, or if there is no criminal investigation, then the committee proceeds to the investigation stage. The first part of it is the committee meets with and interviews the complainant. And a written statement of the complaint is prepared and signed by the complainant. Now, the complainant does not have to write the complaint themselves. The complainant's advisor can assist with this. And also, the advisor can be present at this interview and at any of the interviews as an observer. The second step, the complainant then meets with and interviews the respondent. The written complaint is presented to the respondent. The committee hears the response, and a written response is prepared and signed by the respondent. Now, the complainant's submission is confidential, so a copy is not to be given to the respondent to keep. The respondent can make notes, but not take a copy of the confidential complaint. It's important in the interview with the respondent to present and work through all of the allegations in the complaint. So, for example, the complaint alleges that on this date and at this time and this place, X happened. Can you tell us about that? And the responses may range from denial. The respondent will say it didn't happen. Or the respondent may say something happened, but I recall the events differently. Or the respondent may say, yes, it did happen, and essentially make a confession to the offense. The respondent doesn't have to write a response themselves. Again, the advisor can assist with this. And the advisor can be present at this interview and other interviews as an observer. In the final step here, the committee meets once again with the complainant, presents the respondent's written response, and then hears the complainant's response. The committee then interviews other relevant witnesses, if any. And it's important that witnesses have firsthand knowledge of the alleged events. So hearsay, somebody told me that they saw this happened or heard that this happened. That's not firsthand knowledge. And character witnesses are not firsthand knowledge either. I mean, I'm sure there could be many people who would come in and be willing to testify to the solid exemplary character of the individual. But in this case, that's not relevant. What is relevant is any firsthand knowledge of pertinent to the alleged offense. Although, a comment about hearsay. If someone says, well, you know, so-and-so told me that they saw X happen, if the investigation committee doesn't know about this and has not already interviewed that person, they may want to follow up with because they may have just discovered that there's another person who has firsthand knowledge. The committee considers other relevant evidence, if any. For example, are there any emails? Are there any text messages? Are there any photographs? Are there any medical reports that would document injuries consistent with and corroborate the allegations? The committee prepares its report to the presbytery with its findings and its recommendations, if any. And the committee could structure its report along this lines. There could be an introduction with a paragraph or two outlining when and how the complaint was received and who was named to the SASH committee. A process section which describes the steps that were followed, the initial steps of assigning advisors and pastoral care persons, and the steps that were followed during the investigation, who the committee interviewed, when they interviewed them, what other relevant evidence they received. And then it would conclude with the committee's findings and the recommendations, if any. The committee would inform both the complainant and the respondent of the recommendations that they are going to be bringing to the presbytery. And ideally, they would do that at least 10 days before the presbytery meeting. And then finally, the adjudication phase. The committee presents its report and its recommendations, if any, to the presbytery at an in-camera meeting. Behind closed doors, only members of presbytery are present for that. And all relevant information is shared to assist the presbytery in making its decision. And the committee may decide that copies of the confidential report should be circulated during the presbytery meeting to assist the presbytery in making that decision. And if they do that, the reports should be numbered and then collected and destroyed at the end of the meeting. It would be wise to impress upon the court the confidential nature of the material and also the proceedings that are taking place in the in-camera meeting. So no pictures are to be taken, no recordings are to be made of the meeting, no surreptitious photographs of the confidential report. The complainant has the right to address the presbytery directly. The presbytery determines whether or not the complaint is substantiated. And the standard of proof that's used for this is something called the balance of probabilities. Given all of the evidence, would a reasonable person conclude that it is more likely that the alleged action occurred than that it did not? So it's based on the preponderance of the evidence. If the complaint is substantiated, the presbytery considers appropriate discipline. If the complaint is not substantiated, the presbytery declares the complaint dismissed. And it's recommended that when the presbytery votes on these matters, that the voting be done by secret ballot. If the allegations are substantiated, the discipline depends on the severity of the offense. And we have 4 levels of censure in our polity. The first is an admonition. This is the lowest level of censure. It's essentially a dressing down in private. It happens in cases where the offense is relatively minor, where the individual, it may be a lapse of judgment on the part of the individual. The individual shows remorse and is aware of the nature and the consequences of what they have done. And there is a reasonable belief on the part of the presbytery that the behavior will not occur. The second level of offense is a rebuke. And a rebuke is a dressing down, but in public rather than in private, so before the whole court. This occurs where there is a more willful flouting of sexual behavior, or where the individual has not shown an adequate appreciation of the seriousness of their offense. A rebuke could also include a temporary suspension without pay, or a requirement to enter counseling or therapy. Presbytery could attach conditions like this to the censure. The next level of censure, a more serious one, is removal from office or from position. And this is the censure that is appropriate where the offense is much more serious, where it involves a breach of trust or damage to a relationship with the congregation, and it involves severing the pastoral tie. So the minister would no longer be the minister of the congregation that they're serving in. This could also include a requirement for counseling or therapy to be completed before the minister could seek a new call. And in our polity, presbyteries hold ministerial certificates. And the final and most serious level of censure is deposition from ministerial office. In some traditions, they call this being defrocked. This is appropriate where there is substantial abuse, criminal acts, acts of violence, abuse of minors, or whether there is a significant, deep, and disturbing pattern of abuse. And in this case, the presbytery exercises its authority to strip the minister of their ordination, and the minister ceases to be a minister in the Presbyterian Church in Canada. Now, most often, the decisions of presbyteries in sexual abuse and sexual harassment cases are accepted, but either the presbytery or the complainant can demand a trial in accordance with our disciplinary process. And once the presbytery has made its decision, the decision is communicated to the complainant, the person who filed the original complaint, whatever the presbytery decides, that the allegations are dismissed or that the allegations are substantiated, and the discipline as well imposed. The decision of the presbytery would also have to be communicated to the session and to the congregation. And that could be done in a prepared statement at a congregational meeting following a Sunday service, or it could be done at a separate, duly called congregational meeting where representatives of the presbytery read a prepared statement and can be there to answer any appropriate questions.